हेलो चेक 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 1 2 3 अब तो जारी हो गई आवाज बढ़ा लो वहां की हेलो हेलो चेक साउंड चेक
After setting out the facts, we have formulated the following question. The above background, the question that arises for consideration, whether the notice issued by the appellant to respondent 2 and 3 on 10/6/2015 constitutes sufficient notice and stroke, or whether the respondent number 2 and 3 were entitled to a second show cause notice proposing to impose a penalty under section 27 of the Competition Act. Then we have surveyed the relevant provisions of the statute. We have discussed the analysis of the statutory provisions. As far as the present case is concerned, the Director General's report was concurred with by the Commission, and hence a notice in the nature of the one issued on 10/6/2015, which is traceable to Regulation 21, read with Regulation 48 and 22 and Section 26 of the Act, is enough compliance with the provisions of the Act for the purpose of imposition of a penalty under Section 27. Thereafter, under Section 48, every person at the time of the contravention who was in charge of and was responsible along with the company was deemed to be guilty of the contravention was liable to be proceeded with and punished. The liability was fixed by the statute itself. The notice of 10/6/2015 was categoric in pointing out the fact that there are contraventions alleged in the DG report, and it was clear in fixing the individuals who were the key personnel in charge of the affairs of the respondent number 1. A clear opportunity was given to file reply stroke objections. Respondent 2 and 3 can complain of no prejudice if on the basis of this notice the Commission held them guilty for contravening the Act and proceeded to impose penalty under Section 27. We are fully convinced that the notice dated 10/6/2015 issued in the present case fulfills the requirement in law as it then stood. Then to contrast with the provisions of the MRTP Act, to understand the nature of penalties that can be imposed under the Act, one has to necessarily contrast the penalty provisions of the Act with its precursor, the MRTP Act. Under the MRTP Act, the Commission had limited powers of passing only cease and desist orders. Only after the cease and desist orders are passed, and if there is a violation, certain penalties were prescribed. The net result was a violator could violate the law with impunity, and on receipt of a cease and desist order, cease the activity. There was no deterrent in as much as there was no penalty for the violation, and only a penalty for violation of an order passed by the Commission was contemplated. This was found to be very ineffective. Then we have dealt with the scope of Section 27 and discussed the penalties that could be imposed by relying on an erudite monograph titled Remedies and Commitments in Abuse Cases by Dr. Anna Renata Piskarevic, a consultant of the OECD. We have discussed the behavioral remedies and the structural remedies, the concept which is recognized in the Competition Act. Section 48, as it stood at the relevant time, provided that with regard to body, corporates, firms, and associations, that aspect I've already read. The Act, which is intended to provide both teeth to the regulator, namely the Commission, to check anti-competitive agreements and abuse of dominant position, empowers the Commission under Section 27 to pass monetary penalties as well as behavioral and structural remedies, and such power is traceable to the opening clause of Section 27, read with 27A, B, D, E, and G. The idea was that the contravention be effectively brought to an end, keeping in mind the principle of proportionality. A behavioral or a structural remedy is principally imposed on the enterprise. When a behavioral remedy impinges on corporate governance, corollary orders to give effect to the behavioral remedy may have to be made on individuals. Stricto sensu, the penalty is on the enterprise, and the corollary direction is a consequential direction to give effect to the penalty imposed on the enterprise. Without such powers to impose corollary directions, behavioral remedies and structural remedies imposed on enterprises, which incidentally impinge on individuals, could never be given effect to. The behavioral remedy imposed on respondent number 1 can never be given effect to unless the corollary part of that direction, directing R2 and R3 not to associate themselves with respondent number 1, is given effect to. This also reinforces the holding that the penalty of a behavioral remedy is primarily on respondent number 1, with incidental consequences on respondent number 2 and 3. A proportional remedy is one that addresses the identified competition concern without going beyond what is necessary to remedy it. This implies that in abuse cases, proportional remedies should restore, as much as possible, the competitive situation that existed before the abuse occurred. without seeking to improve the market structure that existed prior to the abuse. Further, length of the application of remedy should be balanced in as much as while it should be long enough to allow intended effects to materialize and short enough to account for the dynamic nature of the markets. We have discussed proportionality in section 27. No second notice contemplated under the statute. In this background, reverting to the question at hand, it will be clear that all that the Act contemplates after the receipt of a report from the DG indicating contravention is to set the procedure in motion under section 26 of the Act as it then stood, read with section 48 of the Act, regulation 21 and 48 of the Commission General Regulations 2009. Thereafter, we have discussed the review committee and the High Court judgment in Mahindra, but we have steered clear of it because there is an appeal pending, and we have said that that concerns the validity. We are on the anvil of interpretation. So we have not touched that case except setting out it as part of the report. With the furnishing of the DG report and the opportunity being given to the parties which have been duly complied with in this case, a fair opportunity has been given to respondent number 2 and 3 to address on all aspects of the contravention. It should also not be forgotten that notice and the supply of DG report is to enable the parties to answer on the contravention. It is for the Commission to maintain the principle of proportionality in the imposition of penalty as prescribed in section 27 of the Act, which may include monetary penalty and behavioral and structural remedies. Considering the importance of fair competition and the ultimate goal of protecting the interest of the consumers, these internationally recognized remedies, the power to impose which is statutorily engrafted in the different subsections of section 27, are within the powers of the Commission to impose. This is the only way that the change that was desired from the erstwhile MRTP regime, which only rest contented with the cease and desist orders, could be achieved. If these penalties are not recognized in the statute, the purpose of enacting the Competition Act 2002 would be defeated, and the Commission, like the MRTP Commission, would continue to be a toothless body. It is also to be emphasized that both SAIL and Excel Crop, time-bound dismissal of proceedings before the Commission, have been emphasized. The ecosystem of competition law provides for behavioral and structural remedies to be imposed depending on the facts of the case as to what remedy will best address the mischief in the individual case and act as a deterrent, not only for the violator, but also generally would be for the Commission to decide. Internationally, these remedies are well accepted, and our statute in section 27 vests the power in the Commission to pass such orders as deemed necessary to check the malaise. The ecosystem of the Competition Act is sufficient notice to the violator that the regulating body has vast discretion and, depending on the factual scenario, can fashion an appropriate remedy. The only check is that it should be proportionate and should have nexus with the object sought to be achieved, namely to punish the recalcitrant party and also ensure that the penalty acts as a deterrent. Providing a back and forth between the regulator and the person in breach to arrive at an appropriate penalty can defeat the purpose of the Act and can be a source of great abuse, as the time given can be used to even present the Commission with a fait to comply, defeating the object of the Act. This will also result in enormous loss of time. Thereafter, we have developed the point of how the notice is to answer the contravention and relied on the associated cement case, a leading case from labor jurisprudence. Once the explanation is offered, it is for the Commission to conclude whether there is a breach of the Act or not. As to what penalty to impose, it will be guided by the doctrine of proportionality when it chooses the penalty or penalties from the menu of penalties available. Further, appeal is provided under 53A and 53T of the Act. The appellate body also shall examine whether the penalty imposed by the original authority is proportionate. By doing so, the appellate authority court is not curing the violation of natural justice, since there is no violation of natural justice by the original authority, but what it does is to review whether the penalty is proportionate. Being an appellate authority, its powers are coordinate with the original authority, and it can even modify the penalty. It is not bound by the constraints of judicial review court exercising powers under article that a judicial review court exercising powers under Article 226 may be faced with. There is no need to remit the matter to the original authority for imposition of an appropriate penalty. The appellate tribunal can itself substitute the penalty. This itself is a salutary safeguard. The behavioral and structural remedy to be imposed will be dependent on what the facts of the case warrant, depending on the nature of the contravention. The most appropriate remedy that will prevent the recurrence is for the Commission to decide. The only requirement is that it should be proportionate. And we have discussed the evidence, and on facts, we have found the penalty to be proportionate. Respondent number 2 and 3 were also found to indulge in similar anti-competitive conduct in case number 45 of 2012 before the Commission, and in that case, a penalty of 7% of their earning The average income for the past 3 years was imposed. In spite of that, they continued with the anti-competitive conduct, resulting in the present case being lodged. It is very clear that mere monetary penalty has not acted as a deterrent on R2 and R3 as well as respondent number 1. A behavioral remedy like the one ordered in the present case would alone protect the interests of the consumers and uphold the majesty of the law. We relied on Mohammad Badruddin to share that past conduct can be relied upon. We have rejected the argument of 19(1)(c) by relying on Article 19(4). For the reasons stated above, we allow the present appeal and set aside the judgment of the compact dated 4/2/2016 and appeal number 99 of 2015, insofar as it set aside the penalty and directions against R2 and R3 and the directions contained in clause D and E of para 9 of the order of the Commission. We restore the findings of the Commission dated 8/9/2015 in its entirety. The directions to respondent number 1 not to associate with respondent number 2 and 3 with its affairs, including administration, management, and governance of respondent number 1, and the directions to respondent 2 and 3 not to associate with respondent number 1 in the administration, management, and governance of respondent number 1 for a period of 2 years shall commence from 1/12/2025 and continue till the period of 2 years is over. Complaints will be filed before the Commission within 3 months from today with regard to all the directions imposed by the Commission in its order of 8/9/2015. No order as to cost. We have recorded our appreciation for both Mr. Arjun Krishnan and Mr. Harshad Hamid, who ably assisted us.
Please, Your Lordship. I'm seeking a listing of an application for direction, being IA number 232345 of 2025. Lordship, the appeal is filed by NSCL, where the issue is whether the assets of the respondent number 1 corporate debtor
After the break.
Gratefully, Lordship.
My Lord, 802, I am seeking listing of IA number 58244 of 2023. My Lord, 6th October is the date already fixed in the matter in respect of other IAs. The same date may be listed in this matter as well. Last time when the matter.
Mr. Jain, we have already reserved for judgment.
My Lord, that's on a different aspect, my Lords. It's
We'll look into your different aspects. Doesn't matter. Where is this IA?
my Lords.
We'll look into your IA. If we find something important, we'll definitely pay attention.
I would pray, my Lords, that it would require some hearing also. Therefore, that aspect relating to pedestrian.
Mr. Jain, we can't keep hearing such matters for an indefinite period of time. We need to say something finally.
My Lords, greatly obliged. Greatly obliged.
Please, Your Lordship, this IA has been filed for intervention in the main matter which concerns discrimination inside prisons
When
in
is
India.
the main matter?
The main matter is listed on the 31st of October.
31st.
If 31st of October is the date,
We'll get it notified on 31st of.
great.
Lordships, if I may, item 54, my lords, is relating to that fraud declaration, the judgment of Rajesh Agarwal. Lordships, yes, my lord, I made that. Lordship, last 3 occasions was directed to be listed top of the board. It was listed again on Tuesday. Lordship, directed to be listed today. There's no noting of top of the board, and I understand your Lordship's board is quite busy. Because there's some urgency because there's a stay of the fraud declaration, and criminal action may be taken, any other coercive steps may be taken. Lords, if my Lordship may kindly indicate.
Now it will go after the break.
My lords, if a particular date, 7th, may be fixed, subject to my lord's convenience.
We are reopening on 7th, no? 6th. 7th, top of the board.
I'm grateful, my lord.
Gratefully, Lordship.
Item 1.
Please, my lords. I'm appearing for the petitioner wife, my lords. And for this wife, this matter was referred to the mediation, my lords. Initially, my lords, in the first round, my lords, we agreed to, we're requesting him to call us back, my lords. We are ready to go back. Even yes, yet still, my
The
lords.
life of how many years?
My lords, 1 year, my lords.
1 year. No child born.
Then, no, child.
Fine.
Then it was referred to the mediation again, my lords. And we have offered them a one-time settlement, my lords. We started
is
from
that?
26 lakhs, my lords. But my lords, we have come to 15 lakhs, my lords.
Okay. He's agreeable to
No,
it?
my lords.
No?
No.
What are you
Well,
doing?
respondent is ready to pay 6 to 7 lakhs. Lord.
What are you doing?
But he is doing nothing. Right now, he's the
My
job.
lords, he's saying he's not doing nothing from last
But
year.
his father is a painter.
1 year, my
My
lords.
His father may be a painter.
father, maybe he's a sales boy. He was a sales boy.
Where? Sales boy.
Sales boy is in Noida. He
What
was
is-
getting a 25,000.
What is your client doing?
She's not doing
No?
nothing, my lords.
Marriage collapsed in 1 year?
Yes, my lords.
What went wrong?
My lords, his father, my lords.
Incompatibility?
Sorry, my lords.
Incompatibility between the couple?
Yes, yes, my lords.
So then part ways. Why are you bargaining? Live your own life. Forget it. We'll
My
fix
lords,
some result.
she's living in a village, my lords, in Bihar, my lords.
Huh.
It would be difficult for her to marry again, my lords. So we are only for requesting, my lords, to pay some amount, my lords, that will.
You are expecting 15 lakhs.
Yes, my lords. That's what my instructions. Are.
You are offering 7
7
lakhs.
lakhs.
Okay, we will cement a little. We'll bridge the gap a little. Okay?
Lords.
Ask your client to be here Monday next.
Next matter.
Right? You need not call your client. She is in a remote village.
Yes, my lords.
Ask him to be here.
No, it's-
We'll fix an amount.
Great for me. Lords. Great.
Hello? Can she appear online? No.
It would be difficult, my lords.
She will be-
Network issues, my
Which
lords.
place is she there? Which place is she living?
Kishanganj, my lords.
That's all in
Kishanganj is the
She
district, my
was
lords. but
online. All mediation proceedings, she was online. Lords.
She was online.
He was online, my
Let
lords.
us sit around and
Ask her
I'll ask.
to be on.
Please.
Yes.
Please, your lordships.
Please,
Lordships,
your lordship.
this. Lord, in this matter, I am seeking permission, my lords, to travel the Nepalese embassy, my lords, to execute the sale documents of my land, my lords, just to meet the daily expenses of my lords.
Your lordships have sought instructions.
Ah.
As on today, there are 7 witnesses examined out of 14. That's number 1. Number 2, post the order of this honorable court on section 16 of the UAPA. The matter has gone to the High Court and the next date is October. The High Court has called for the records in relation to the committee having examined the matter to provide sanction in 2021. Trial is progressing at a reasonably good pace, but your lordship, it's being interdicted by this section 16 issue, which is pending before the High Court.
What is the section 16 issue?
The issue was that sanction for prosecution under section 16 of the UAPA was not.
Today, the only prayer is, he wants to come to Delhi to execute some sale
Sale
deal.
document, my lords.
No,
So what is the
but
problem? Is
Yeah.
there any apprehension that he?
the apprehension only that I've been instructed to say before your lordships is this, that he's a foreign national and provided in lieu of this sort of an exercise, he should not escape the jurisdiction of.
Where is our order releasing him on bail?
Yes,
Well, I
your
am
lordship,
based on-
they filed an application for directions, if your lordship finds.
What direction?
Application for additional documents. I'm sorry.
Vinay, just take us to the.
Para 34 of the order.
Para?
34.
Main file. Main file to 11 pages की है. The additional file. Where is that order passed by us?
My lords, it is at page 29 of additional application for additional document, my lords.
Okay.
The relevant para is page 29, my lords, of the application, my lords, for additional document.
Only suggestion is that over here, then he may continue to report to the police
that
station
can-
while he is here,
That can-
if your lordships are inclined to permit him.
Anyway, he is outside.
Yes, he's outside. He's on bail. He's reporting to the police station.
Lords, I am
fortnightly
complying with the directions, my lords. I am
As
complying
per
with
the directions of this court, he's reporting.
Take down.
Yes.
The applicant was arrested in connection with crime number 01 of 2015, registered for the offence punishable under sections 489 capital B and 489 capital C of the Indian Penal Code 1860, IPC for short respectively, and under section 16 of the Unlawful Activities (Prevention Act 1967) UAP Act for short, by the ATS Police, State of Uttar Pradesh. Good point. The applicant was ordered to be released on bail by this court. The order dated 18th of July 2024, passed in Criminal Appeal number 2790 of 2024. Good one. While ordering his release on bail, this court imposed the following conditions. There are 34 bracket II, then small a, b, c, d, e. Good one. The applicant has been scrupulously abiding by all the directions issued by this court referred to above. Today he is before us with an application making a request that he may be permitted to travel to New Delhi as he needs to execute a sale deed with respect to the land owned by him. It is his prayer that he may be allowed to be in New Delhi for a period of 1 week. Or for the number of days required to complete the formality. Look, we heard Mr. Learned Counsel appearing for the applicant accused and Mr.
Sahai,
Learned Counsel appearing for the state of Uttar Pradesh.
please.
We are informed that the trial is in progress. Almost 7 witnesses have been
7 out of
examined
14.
so far. Good point. We are of the view that we should permit the applicant to travel to New Delhi for the purpose of execution of the sale deed, subject to certain terms and conditions. 1. He is not supposed to leave which city?
He's supposed to report to Lucknow and the police station concerned and not leave without permission.
The applicant shall furnish his entire program. The investigating officer attached with the Lucknow police station.
Please.
ATS.
ATS police station, yes.
The program should contain all necessary details, that is, the date of his departure, the place where he is going to put up during his stay in New Delhi, and the date of his returning back to Lucknow. Okay? 2, he shall also file an undertaking that once the execution of the sale deed and other formalities is completed, he shall go back to Lucknow and continue to abide by all other by all conditions imposed at the time of grant of bail. Right?
Yes.
Third, we direct the applicant to keep marking his presence every day at the Chanakyapuri police station, New Delhi.
Please, if he's going to the embassy.
He's going to the embassy, that's.
It's
My lords,
covered with-
Tilak Marg police station is near, my lords, near to Bharat.
Tilak
Tilak Marg police station. Please, your lords.
Till he is in New Delhi, till the time he is in New Delhi.
Please,
Okay?
your lord.
Take down. Registry shall forward one copy of this order to the ATS police station, Lucknow, one copy to the Tilak Marg police station. Okay?
Srikanth,
Please, your lordship.
I moved a counterfeit matter before Justice Manoj Mukherjee. After the case, he told me, take your fees in draft.
Please, my lord.
With the aforesaid, this application stands disposed of. Dusty permitted, input Dusty.
Your lordship, only one request. Your lordship may prescribe a outer time limit, because if it's indefinite, he's asked for 7 days, he's not prescribed.
Again, we clarify that the stay of the applicant accused shall not exceed a period of 10 days.
Grateful.
Please, your lord.
And in case of any difficulty, he should come back to us.
Please, please.
Obliged, your lordship, please.
Grateful to your lordships.
Please, your Lord. Lords, the interim protection was granted looking to the nature of dispute being civil. The precise submission with utmost respect is that this order deserves to be made.
You are praying for anticipatory bail.
Yes,
Yes, sir. What is the?
The co-accused was also extended. The co-accused was also extended bail by my lords.
Oh, but
by the
why did
I
you
understand.
register this FIR?
Lords, I understand that question had also fallen from my lords during the last bail application. So
The petitioner, a lady aged
50 years.
50 years, has been denied anticipatory bail by the High Court of Punjab and Haryana in connection with FIR number 282, dated 27th of September 2023, registered with Jhajjar City Police Station for the offence punishable under sections 420, 466, 467, 468, and 471 of the IPC. We heard Mr.
Yeah.
the learned senior counsel appearing for the petitioner accused, and Mr.
Saksham Ojha.
learned counsel appearing for the state of
Haryana.
Haryana. Next. While issuing notice, we directed that the petitioner shall not be arrested. Having regard to the nature of the allegations leveled in the FIR, and also considering the fact that the husband of the petitioner
Yes.
has been protected by this court, we are persuaded to exercise our discretion in favor of the petitioner, insofar as her plea for grant of anticipatory bail is concerned. This petition is allowed. We order that in the event of arrest of the petitioner in connection with so-and-so, she shall be released on bail subject to the terms and conditions that the investigating officer may deem fit to impose. With the aforesaid, this petition stands disposed of. Trustee permitted.
Deeply.
Grateful.
Masudi? You retired as judge of the Allahabad High Court? Yes. How liberal you were in grant of anticipatory stay? Huh?
Tomorrow you have a matter this side.
I find it more interesting now.
Over here. Oh, enjoy yourself. Next matter.
Your Lordship, in item 4, I appear for the state. Your Lordships may kindly have PDF page 55 of the court file. I just mean to
Cancellation of anticipatory.
Oh, I'm sorry. I'm sorry.
Your Lordship may kindly have
This
PDF.
is 4, no?
Cancellation of
Just a
anticipatory.
minute. Just a minute.
Yes,
You are praying for cancellation.
yes, Milord, I'm the victim, Milord. And
What is the offense?
offense 376 and other allied sections, and we were on YouTube and whatever they say. And then there was this, thereafter he started exploiting me, and
So
thereafter
the High Court of Patna granted anticipatory bail.
Please, Your Lordship.
and they have filed a.
For
Your Lordship, I appear for the state. Your Lord-
state.
State Lordship, we have filed our counter PDF page 55 of the court file, Your Lordship. I just mean to bring this to Your Lordship's attention in para 6,
What is the name of the accused?
Mahesh.
Mahesh Sahni, Lordship.
He is the only accused?
Yes, Milord.
And what weight with the High Court in granting anticipatory bail?
We clean antecedents.
No. What is the date of the incident?
There's a
7
1.5.
2024, Lordship.
7.
7 June 2024.
What is the age of the victim?
Your Lordship, on the date of the incident, it was 20.
Unmarried lady?
Your Lordship, that we'll have to verify.
And the accused, he is a married person?
Married with 4 children.
4 children. Okay. On which date the FIR was registered?
20 July 2024, Your Lordship. So, admittedly, after a month's time.
1.5 months.
After 1.5. What is the reason for this belated FIR? Any idea?
Your Lordship, that the informant, the petitioner, may be able to.
So what is your assessment of the matter appearing on behalf of the state?
Your Lordship,
Were they in some relationship, some extramarital affair or something, or it's a genuine case of rape?
Your Lordship, there is an informatory petition that had been filed by the respondent number 2. So it is their case that due to this informatory petition that this is a counterblast FIR. Your Lordship, we've stated in the FIR that
You are a
the
married man?
Yes, yes, Lord.
How come you are in a relation?
I will read yesterday, Lord.
What chart?
I will show you, Lord, how they are related.
No. Do you have any antecedents?
No, Lord.
Do you have any antecedents?
No, Lord.
He is talking about your
No,
antecedents.
he said that the High Court has granted the bail only on the ground that he is having clean incident, no other incident.
Okay.
It says,
and your-
cooperating with the investigation and there's blackmail, the audio recording, we can ask the.
Have you appeared before the IO?
This is a lot.
How many times
No,
have
no,
you?
What is going on? The IO has never called Lord. First of all, Lord, the petitioner, Lord, is the niece of the respondent number 2. That's why, Lord, I prepared a data file chart. Can you see?
So Mr. Prem Prakash, just come to para 10 of their counter.
Yes, sir. Yes, Lord.
After 82, 83. No.
Para 10, Your Lordship, Para 6 is also important. Non-bailable warrants were issued. 82 proclamation was also issued because
Prior
he's
to that.
absconding.
It is, my lord, not a close.
To para 10 in
Was
apropos,
this,
my brothers.
was this pointed out to the High Court?
No, Your Lordship, it was
Why?
not pointed out
Why it
because
was not pointed out?
on the very day that the anticipatory, the petition was first listed, it was disposed of on the very same day. So this submission has
Take
not.
second, 1 second. He moved an anticipatory bail application,
Right, Your Lordship.
and on the very first day, the court granted bail.
Your Lordship, as per,
No notice was issued to the state.
Your Lordship, there
That
is,
means that the public prosecutor was not heard.
he was heard, Your Lordship. They were the state representative.
One advance copy is served on the date of the hearing.
Your Lordship, pardon Your Lordship, there is only one order of the Honorable High Court, and that is the order in which,
Did you point out to the High Court by way of a report or an affidavit that he is absconding? He has been declared to be a proclaimed absconder. Proceedings under Section 82 have been initiated. Did you bring it to the notice of the High Court?
Your Lordship, that,
Why you didn't bring it to the notice of the High Court?
Your Lordship, that is admittedly a lapse on the part of the State Council.
My lord, what I'm submitting, kindly hear me for a moment. 1 minute.
Yes.
1 minute. The petitioner, father, my lord, and the respondent, but that's why I prepared chat, should not be seen this by great, my lord, the understanding of the matter.
Para 10. You are keeping, according to them, audio recordings are there. You
Yeah.
back where you are not appearing before the
If
court.
that is so, my lord, I am submitting, my lord, a categorical statement before the bar, my lord, that the respondent number 2 has not made a single call to the petitioner. The petitioner, I am submitting, my lord. Kindly hear me, my lord. What? For 1 minute.
There's a counter as well. Counter appeal.
Oh.
The respondent number 2, my lord, is the uncle of the petitioner. There is a partition dispute, my lord.
Take down.
Not hear me for a moment, my lord. My application for anticipatory bail was pending before the High Court, and there they are saying that in the meanwhile, the respondent who was declared a proclaimed offender.
The respondent number 2 herein, original accused. Sorry, I can't.
Not a single call has been made, my lord.
Leave granted. This appeal arises from the order passed by the High Court of Judicature at Patna dated 24th of February 2025 in criminal miscellaneous application number 4149 of 2025, by which the application filed by the respondent number 2 herein, original accused, seeking anticipatory bail in connection with the first information report number so-and-so of so-and-so, dated so-and-so, registered with Sitamarhi Police Station,
Your Lordship, Bela
Sorry.
Police Station,
Bela Police Station,
District Sitamarhi.
District Sitamarhi, State of Bihar, for the offense punishable under sections 341, 323, 376, 504, and 506 of the Indian Penal Code, for short the IPC respectively, came to be allowed.
There are 4 occasions.
The father of the victim, being dissatisfied with the impugned order passed by the High Court granting anticipatory bail to the accused, is here before us with the present petition, with the present appeal. We heard Mr.
Mr. Sanyal Millets.
Learned Senior Counsel appearing for the
I'm just,
petitioner.
I'm your
Learned Counsel appearing for the petitioner. Miss
Rebecca Mishra, Lordship.
the learned counsel appearing for the state of Bihar, and Mr.
Already 3 accused have been granted.
the learned counsel appearing for the respondent number 2, original accused. Good point. The first information sport sorry, we take notice of the fact that the alleged, sorry, that the date of the alleged crime is 7th of June 2024. The first information report
20th July.
came to be lodged
20th July.
who lodged this FIR? Every time you don't have to flip the pages. You must be
Ex,
ready.
Millard's ex lodge, the lady,
Father or the victim?
victim Millard's.
क्या लिखा आपने? By the victim on 20th of July 2024. The FIR reads thus. Got it. Right? Sure.
Ex.
We also take notice of the fact that the respondent number 2 is a married man and a father of 4 children. The victim at the relevant point of time was aged 20 and happens to be the niece of the respondent number 2. Good. After we issued notice, sorry, in pursuance of the notice issued by this court, the state has filed its counter dated 25th of August 2025. We should take notice of the amendments made in para 10 of the counter, which reads thus. Good.
It's also she. Yeah,
Para 6, we should take notice of the amendments made in para 6 and 10, respectively, of the counter. Quote them. We wonder whether all the relevant facts were brought to the notice of the High Court at the time of the hearing of the anticipatory bail application. First of all, unfortunately, the impugned order passed by the High Court is very cryptic. We do not want to say anything further as we are inclined to set aside the impugned order and remit the matter to the High Court for fresh hearing of the anticipatory bail application. First of all, in such circumstances referred to above, this appeal is partly allowed. The impugned order passed by the High Court is set aside. The matter is remitted to the High Court. The High Court shall hear the criminal miscellaneous application number 4149 of 2025 afresh on its own merits. Before hearing the application afresh, the High Court shall call for an appropriate report or affidavit from the investigating officer. After hearing all the parties concerned, the High Court shall take appropriate decisions in accordance. Right?
In the meanwhile, Mr.
So you have arrayed other members also of the family?
Yes.
All?
Yes, my lord.
Why?
Your Lordship.
And what happened to those? They have been arrested and released on bail?
Yes, my lord.
There was a fight, Millards. There was a fight when this affair, when the lady burst out. I mean, she said, I'm not going to get blackmailed anymore. I'll go loud and clear.
All the three have been
That's why
granted.
there was a fight, Millard.
Next matter.
Grateful, Lordship.
May it please, your Lordship.
Please.
Look, item 5 is a group of NEET PG matters, my lords. Some of these are legacy matters and some of them are fresh matters. My lords, as far as the fresh matters are concerned, the issue that we are raising, my lords, is in relation to disclosure of, my lords, the questions and the answer sheets. My lords, now this NEET
This exam is over.
exam is over.
On which date?
25th, August.
So 3rd of August.
3rd August. my lords. That, my lords, your Lordship's addressed, yes, my lords.
That is solved, my
Yeah,
lords.
that is solved, my lords, to our satisfaction. Exam went, my lords, well.
Results are declared.
Results are declared.
Now what do you want?
Yes, my lord, now the issue is, my lord, the exam is, my lord, conducted as a multiple choice question exam with 4 sets. Now, my-
How many students appeared in this exam?
Lordship, 2,42,400
How
approximately.
many are before us today with this prayer?
Your Lordship, there are 14 petitioners in Meghraj Roy versus this.
Around 20 students.
Out of 2 lakh students who appeared in this PG NEET,
Your Lordship.
why 14 have to redress this grievance?
Your Lordship,
I'll just indicate, my lord, I quite see what's falling from your lordship, my lord, but this issue, my lord, is an issue which will affect not just this batch of students, but also
Your result is also declared.
result is declared.
Correct.
Result is declared.
Today, what do you want us to do?
My lord, I'll just,
To alter your result?
No,
in
my lord.
accordance with the directions.
we are not seeking that, my lord. What we are seeking is, my lord, disclosure of the questions and the answer keys. And this is pursuant to your lordship's judgment, my lord, in Bhavna Tiwari, where your lordships had, my lord, directed, where your lordships had, I'm sorry.
So you know, na, you have appeared.
My lord, that is the catch here, my lord. I'll just indicate, my lordship will give me 30 seconds. Yes.
We'll have to hear that.
Yes.
There's no impending urgency in this.
The only slight urgency, if I can, my lord, put it before your lordship, is that the counseling process may begin any time.
Oh, we are
And
not going to disturb.
we are not, my lord, seeking any disturbance of that.
Some 20 students
We are not
who come
saying that, my lord. We are not even attempting to say that.
If it on any NMD day.
Your Lordship,
May I just say
allow me to
this?
submit.
May I just say one thing? my lord? May I just say one thing? Because we are not going to come in the way of any counseling. All we are seeking is that our questions and our answers are disclosed to us so that, my lords, we know where we stand. And ultimately, my lords, if there is any possibility of us seeking any sort of revaluation, we are in a position to do that.
Your
So
Lordship,
today, my lords, we are in a position.
It's a distance proposition.
Yes, my lord, today we are in a position.
It will upset the entire.
And we don't wish to do that. We don't wish to.
We'll hear you, but not today.
Your Lordship, kindly allow me just 1 minute to present my case. Your Lordship, I'm appearing in Meghraj Roy versus NB. Your Lordship, this case, Meghraj Roy, is not just about the transparency issue. We have raised discrepancy, we have raised irregularities, we have also alleged irregular, unscrupulous malpractices, Your Lordship. If Your Lordship may allow, I'll hand over the handouts. That is a brief of the case, Your Lordship.
Can't hear it today.
Your Lordship,
We have no time today. We have 70 matters to be taken up immediately after reopening on any NMD.
and Your Lordship, pertaining to the question that only 20 petitioners have come before Your Lordship. Your Lordship, we have issued a Google form, whereas Your Lordship, more than 2,000 candidates signed, and there are groups, Your Lordship, more than 5,000 students are affected by this.
Out of 2 lakhs, 5,000. Next
And Your Lordship,
Lordship,
allow
So I
me,
would only request,
Your Lordship, allow me to.
I would only request not on 8th and 9th, my lords, on any other day.
File your counter.
My lords, your lordships did not issue notice, my lords, on the last date. Your lordships wanted to hear me on that, my lords.
Formal notice issue. karo.
Well, also the IA numbers.
In 5.8 and
File your counter by the next day.
please, your lordship.
5.9 only.
My lords, there are 3, 5.8, 5.9 and 6 in which notices have.
My lords,
Election now,
mine
please.
is 5.4, my lords. We had first filed a petition in 2021. So every year, different batches of students have been filing petitions. My lords have not heard this matter. That no answer key, no access to question paper, no even option of revaluation. So my lords, it's 5.4, my
I
lords.
have a suggestion for you. Maybe just collate all the outstanding issues, my lords, and present a chart.
My lords, we have put the answer key also on the portal for each
My lords, we'll
candidate.
argue that they haven't,
That is
they've just put
factually
a-
incorrect.
We'll show it, my lords.
We'll place a chart, my lords, of all the
Just issue
formal
notice today, formal
All the
notice.
My lords, we've complied with all orders.
And the respondents to file their counter by the next date of hearing.
My lords,
Your
also,
Lordship,
IA
one last
5.4,
submission, Your
my
Lordship.
lords.
I have.
Just 1 second. My lords, in 5.4, we have filed an IA which is pending for 1 year, where we have placed all the relevant judgments also. So at least my lords may also take our IA on record.
When do you study? When do you study? You should get out of all these litigations. Concentrate in your studies. Why do you keep coming
My
to
lords,
the court
my lords,
complaining, this is not
Your Lordship,
that is not
my lords, NEET PG is the only postgraduate examination in India
Studies.
where there is no question paper, no answer key, no answer sheet.
My lords, we
My lords, we
put
will
down
see
the
simple
statement.
My lords, we will.
Listen, stand on your own merit.
Your Lordship,
Out of 2 lakh students who appeared in this exam, why handful of students have lot of complaints to make?
For the last
Lordship, if I
5
can
years,
submit to
last
that.
5 years, multiple petitions are before my.
Your Lordship,
Lords, may
one last submission, Your Lordship.
Lords,
Chip
may
indicate
kindly-
I have-
the date after reopening.
My lords, may kindly give us 2 weeks, my lords, to file
So
this.
the date after
application.
reopening, your lordships were indicating, my lords.
2 weeks दीजिए और कोई एक
And common chart will submit.
serve a copy to them well in advance.
Please, my lords, we will.
Reminder, if any, you file it.
We'll do.
Your Lordship, one last submission. I have filed an application for de-tagging of this matter. Item number 5.8, Meghraj Roy. Your Lordship, because other matters pertains only to transparency.
On that, on that.
Your Lordship,
Take the issue and give a common issue.
Yes, my lords.
Lordship, these are issues are not
We'll
common,
put
Your
a
Lordship.
chart, my lords, which
Issues
will
are not common.
You can identify separate issues, common issues.
common issues so that your lordship sees only that chart.
Your Lordship.
In Meghraj, we have complied with your lordship's order. We have put the result.
Okay.
Please.
We are grateful to your lordship.
Again, a false statement. May it please from us. Well, with respect, the Honorable High Court judgment is in teeth of Section 260 capital A. The questions which were formulated was decided in my favor, and then 2 questions which was never formulated has also been looked into. Kindly see,
The tribunal order, you get that. Confined to one question only.
only one on business laws. So the Honorable High Court at page 827 rightly only notes that.
862 also.
Lordship, please. I am so grateful.
Issue notice.
Grateful. Well, I'm also praying for a stay, my lords.
What stay?
Well, it's ultimately on the demand, my lords, if you come for person to this.
No recovery for the present.
I'm so grateful.
Yes.
No, this is part of the anti-tax batch laws challenging the virus of the petitions. No, same order may be passed. my lord.
Same.
Milord, I appear for the petitioner here, Milord.
Yes.
Poor man, Milord, the dispute of only a small plot of land, Milord, 102 square yard is a 75 plus years of gentleman, Milord. Milord, there are 2 courts they have held in my favor. Now that the matter is, Milord, fixed before the High Court in 13th of October, a direction for